what IP, the difference of IP, patent, copyright, industrial design, geographical indication, all those things. Okay, so the IPR can be group of rights like a creative labors and what confer exclusive to right holder. That what exactly the exclusive rights to the make or sell, or you see I have the right property, I have the rights to develop this one. I can able to what make, what sell, or I can capable of doing anything. So in you are the people, you are the one small company, you are developing one items. So that things you are capable to sell also. But thing is that you supposed to get what, get a permission for whichever what you are going to make. Okay, so here what is the real property wise intellectual property? See, you people, your parents or your grandfathers having the property of like a 10 acres or 5 acres. That 5 acre land or 1 acre land, you are the owner. So you have the rights to occupy the place, utilize the place. You can use, you can sell, you can do anything with that particular property. So you have that evidence to get from the government. It's all about what you know that you have the what the evidence you have from the government. So here also the intellectual property, you are the supposed to, you are innovated one new thing, or one new music or new poem. So these things you can be, one is you can be able to patent, or you can able to get a copyright, or you want to be do any trademark for your business, or you want to be indication with your what place. So you can do with anything. For that you have to get permission from the government. For that, that's all about what intellectual property. What you are intellectually you are done something. You want to be recognized by the government or the entire kind of world. So you supposed to get this from the government. That is all about IPR filing. Okay, intellectual property right filing. Okay. See, I'll tell you, see, before we are legislating the framework for IP administration. See, in 1970, see, generally how we are filing, it's all about what the Patent Act 1970. The amendment, see, after that, there are several amendments are what there act as the three times with respect to what 1999, 2002, and 2005. They're bringing some what the permissions and what the rules. Okay, in the rules like 2003, 5, 6, 13, 24, and finally they're done with the 2016 also, are the different what the refinements are done and enforced in the act of what 1970. Okay, so generally before you supposed to know what we supposed to be a patentable or what not supposed to be a patentable, where that website, how we supposed to file, what are the things we can do with that, everything I'll tell you one by one. Okay, so the Trademark Act 1990 and see similarly for geographical indications of goods 1999 and the Department of Educational Conversion 1957. So many things are there to we need to know that exactly what are the things the patent law as a concept. Okay, the creation of the mind, generally you know the creation of a mind, what exactly the creating of a labor's executive, and what the rights hold we have, what type of rights, whether I have the rights to ask you the questions. Nobody cannot ask like that question. Somebody have the authority to act the questions to you, then only you are supposed to be capable of to reply them. Okay, your faculty is asking questions, they have rights to ask you whatever the questions may be with respect to what your grade or your discipline or any other activity they are supposed capable to have. So they have the rights or rule, they are supposed to ask questions about you. The similarly that the rights, I have the rights to ask you the question. I have the rights to carry of what 2 crore rupee from here to there. I have rights to what design these things. I have rights to sell these things. So how everything we get the permission from the government. It's all have the rights. Okay. So thing is very simple. So the specifics of like I'll tell you. See here generally you know the patents in India. the deep divided into the Indian patent system, the including what patentable requirements and filing process, post grant procedures, and you can touch the recent changes and upcoming what development India patent law. See, Narendra Modi ji also they done with so many of what refinements in the patent act and so many things in the recent years. Okay, and the trademark and the geographical indication, they explain how the trademarks and geographical indication protect the branding or origin of the product in India, like origin, like Rajasthan silk or Banaras silk, okay, Kanjipuram silk, or you can say what Salem mango. So, including the practical examples of well-known Indian trademark and Talapagattu biryani, Dindukal biryani. So, these are the trademark or geographical indications like Tirupati Laddu. You can say any number, you know already these are the come under what geographical indications, or these are the come under the category of what trademarks. So you can say anything in the what you know with respect to what intellectual property right you supposed to be categorized. Like I wrote one poem. Okay, what is this poem? I supposed to be a new one. It is not anywhere. I not copied. So how they you supposed to you have to get a copyright. Okay, only for a product or process we supposed to file a patent. Other things we get only copyright. Remaining things we can say for a trademark or geographical indications. Only the four way we can do with our intellectuals. Okay, so the enforcement and the commercializations, I'll tell you before we are going to see about the enforcement and commercializations. I'll tell you where what are the things are there. See, in generally these are the four things. One is a patent, one is all about what a patent, trademark and geographical indications. See, four cities like Kolkata, the Kolkata head office for patent office for a design, okay, and as well as what for a Delhi for what patent filing, okay, and the branch we have branch in Kolkata, Delhi, Chennai, and Mumbai for a headquarter for a design filing. You see, you done a design one fan. See, there is only a three wing. You are supposed to include a four wing or five wing. Then it will compare to the what consume of what power and with respect to cost and everything. It's yours is so affordable. Or you done some changes in the design, so it's all come under the design patent. Okay, so design is somehow different when compared with these things. What what patent filing, copyright, and what geographical indication and trademark. So head up is like Mumbai, what Mumbai, Mumbai for what trademark registration, Chennai for a geographical indication registration office. So Chennai have the office for everything, but generally they're taking responsibility for what geographical indication registration overall India, Chennai is the head office. For a design overall India, Kolkata is the head office. For a trademark registration overall India, Mumbai is the head office. For patent office, or head office Kolkata as well as Delhi. Okay, so this is how generally the entire patent filing. So for as a student, you supposed to be capable to write this exam, a patent agent exam. After completion of your degree, you are capable to be like a what a examiner or any other clerical or some other post. You can get it in the IPR office also. It is a government, central government office. If you are if you have the knowledge, you can start now only that what a patent act 1970. If you study from thoroughly, like 160 act is there. Okay, each act, so many things are there. You're supposed to start study now. After completion, your graduate only. If you cleared, you supposed to be like there are so many patent. What what to say? Corporate also is there. You can possible to get job there, or otherwise you can run your own office, or you are capable to work with any patent office like university, college, anywhere you can, or you can be a place to get into that. Okay. So the laws and regulations of Patent Act 1970, the amendment I already told 2002, 5, and the recent also they done like what to say in 2006, 13, 14, 16. So many amendments are done. Okay, this amendment act or this refinement and all where they supposed to do. See, generally what they will do, they will it's all the pass the bill in the what parliament and then finally come to the conclusions. Okay, if you want to deposit, if you want to do any experiment with respect to biological molecules, you supposed to deposit your biological molecules into what the PCT Act. Okay, and Budapest Treaty also. One more thing is there. So many. I don't want to tell much more technically. I'll tell you the overall glance what exactly patent laws and regulations. Okay, so legislative measures and the patents. This I done. I told you, no, like 1995, the mailbox of parametrical and what amochemical products exclusive marketing rights. They done some refinement. In 2000, the patent term in what increased up to 20 years. Earlier it was only 5 years. They are making it to the 20 years. The define of initiative. So many refinements are done. We have met our what international committees with they are done with the things, and the patent laws and salient features. Both product and process patents are provided. The term of the patent is 20 year. If you done once, you get the what finally your patent is granted, you are capable to withstand with the right of 20 years. And the examination on request, both the pre-grant, post-grant opposition, and the fast track mechanism for what disposal of appeals, and provide for protection of biodiversity and traditional knowledge. And the publications of what the applications after 18 months with the facility for yearly examination also is there. See, generally you supposed to file a patent, you need some amount to pay. After that, it will take hardly 18 months for first examination to get over. If you want to publish that application immediately, you suppose go for yearly examination publication to get your application to what publish in as much as early. Okay, the substance are reduced at timeline, and so this is how generally the patent law and the salient features are there done in the recent advancements. Okay, the safeguard in the patent law. See why? See, I done something. I wrote one poem. I written one relics, lyrics of some what movie or something. I want to protect that. Okay, now recently how Ilayaraja is claiming I done this music. I put the note. I only composed it, so I have the copyright. Nobody is supposed not to be used without my what consent. So this is all how it is there happening with respect to what copyright. So the compulsory license to ensure availability of a drug at responsible prices. See, you made any one advancement, you done with what mere arrangement or rearrangement, you done with the composition of two things. If it is to be useful to the public, then only. If it is not to be useful to the public, it is any harm thing to the public, we are not supposed to be file a patent with respect to our invention. Okay, the provision to deal with the public health emergency, like recently we got what COVID, affected by COVID in 2020 and 2021. At the time, there's so many what in the medical field and all, they done with the patent. They're done with the relaxation of that. Okay, revocation of the patent in public interest and also be security consideration. So this is all the safeguard in the patent laws. Okay, we cannot to do us like that. The scope of the patentability under the Patent Act, I'll tell you here what we supposed to be invented, what we not supposed to be make to invent. Okay, so here I'll tell you and this exactly what exactly the patent. Okay, the enforcing of IP rights in India, the exploring the legal options. See, these exploring of legal options are available in IP rights. The whole to enforce the right in case of what infringements. Okay, the IP valuation or commercialization is very important. The strategic for valuing of IP asset and what leverage for them at commercial against the what license or technological transfer. So this is how generally you supposed to know that what the enforcement when the act is upon. Okay, how we supposed to be in what safeguard of our protection with respect to our own what intellectuals, and how we make true what develop any new thing or make a commercialize in the what commercial way. Okay, so this is how generally you know that see, this in our today topic with respect to what exactly they state that the IP management for startups. See, you have an idea, sir. I have an idea. See, we cannot all the ideas we cannot to be patent. Whether this idea is whether unique, sir. I have one fan, sir. With that fan, I want to add one more what what I want to add with that fan, some other things. Down to that, I want to add one light. Okay, already fan is there, light also invented. We cannot add two known substance with cannot to say it is what a new invention. Okay, this is all about what rearrangement or rearrangement or mere arrangements. We done with the already exist something. We if you done with some mere arrangement or rearrangement, it's not supposed to be a patentable. Okay, so if IP is a okay, you want to do some startup or what with respect to what SMEs, that is all about what em- what to say. Uh, say MSME, MSME, that is all about what micro, small, medium enterprise. Okay, this is the registered in India can be beneficial for startups, but also important to understand the purpose and it is aligned with your specific need. These are also very important. The benefits of MSME registration before you go into startup, you supposed to be start with what incubation, then later you can what promote or what take it to the next level of what startup. Okay, what you supposed to get from what that forum is there, na MSME. This is micro, small, medium enterprise. Through that, you can get the financial benefits, government support, and enhanced credibility. Also, you can get it. So, what kind of financial benefit you are supposed to get? They easily access to the loan from the bank and financial institution at the low interest. Okay, due to what a government scheme for MSME. Okay, the subsidy and the tax benefits on various aspects like electricity, direct tax, and what a patent registration, all those things you the fees to be a way of. Okay, and government support. What government support? What kind of government support you will get for your what incubation? Make it as a what startup. The participation in government trend specifically for MSME, the opening of a business opportunity, and the eligibility for participation of government what procurement program and scheme. So that is all they give the support of what government support and enhance credibility. This MSME registration lend the sense of what legitimacy and proficiency to your startups. So it shows a lot of wide publicity about the particular thing. So the micro level generally they use it to give the fund for 1 lakh to 10 lakh and a small investment like 1 lakh to up to less than 10 crore. If medium means 10 crore to 50 crore of manufacturing, in that what 2 crore for manufacturing, 5 crore for service. So there are so many things are there. And the startup first and MSME, I want to supposed to tell you here the focus and funding. See, the focus is all about the startups are often prioritize the rapid innovation and the growth, while MSME might prior the stability and what portability. So for funding, the startups are often really what on venture capital and what agile investors, and while MSME typically depend on it what traditional bank loans. Okay, so this is all about one thing. And long term or short term, what exactly the startups may have the high risk for failure, but potentially with the high growth also is there. The MSME generally they aim to sustainable long term growth only. Okay, so you have an idea, you supposed to come up with your MSME office is there. You can go there. You do with the incubation. You what develop on what a prototype. You have to done with what exactly you supposed to can be things to be done. Okay, and according to that the financial need and what all these things you can supposed to get and government benefits and the procurement opportunity and what you require you will get it everything. Okay, so this is all about general things. And now I'll tell you what exactly that inventions. The invention means a new product or process involving an initiative steps and capable of industrial applications. Okay, the patentable subject matters. The invention must be related to process or product or both. It's supposed to be a process, and I have one process with it. If you done something like creation of tea, there is some set of processes there. Or product, you are doing something. So it is a new one or a new process. Then it's supposed to be what patentable or be a new or novel. Okay, involve one in what inventive steps. there is supposed to be inventive steps. Without inventive step, there is no what the your application not to be select. Okay, be capable of industrial applications. See, I'll tell you here, be a capable of industrial applications. See, gas monitoring system in your home, this small what school project, gas monitoring system like carbon dioxide, carbon monoxide, methane, so many what hazard gases are there. We can easily to monitor that gas like a small LPG gas leakage monitoring system. Okay, the same things we have to be set up for industrial IoT. That is what all about what industrial IoT, like coal mining, okay, or some other mining. There are, if you're digging what land, we are getting so many hazard gases are there. Through that, in the same kind of what application we have to deploy for industrial IoT. It is all about what industrial applications. Okay, this is all capable of what industrial application, not fall under the section of what 3 and 4. Say I told you that already there are 160 what 160 patent act is there. So the act of like 1 to like 3 to 5, it's all about the patentable inventions, patent application for S5 to S11. Okay, opposition 25 to 28, anticipation 29 to 34, and secrecy 35 to 45. These all come under the category of Act, Patent Act 35 to 42. Okay, if you want to get a grant, it's all come under the category of 43 to 53, and amendments all talk about 57. Okay, restoration of the patent is 60 and 61, 62. Okay, registration of patents all come under a category of 67 to 72. The patent office is talk about all activities, what's happening in the patent office. It's all talk about the 73 to 76. And finally, the patent what procurement of line like 77 to 81 is all what miscellaneous. Okay, so this is all, so many things are there, the patent manual, and so many things are there. So not fall under the category of what section 3 and 4. Okay, new means what? What is mean by new? What is mean by what innovation? What is new mean by what new thing I found? Okay, any what discovery? Okay, this invention must not to be a published in India or elsewhere. If I have one idea, it not supposed to be published not only in India, in anywhere. The superior public knowledge or superior public use within India, we can get. There is some database is there. In that you can easily get through all these things. I'll tell you how you supposed to get that one. And claimed before in any specification in India, anybody claimed for a particular product. See, like some machine I found, some machine I am used for agriculture. Okay, this agricultural machine, nobody not used anywhere, nobody is not designed the same set of way how you are designed for utilization for agricultural. So this is how what in that you are climbing, whether nobody is not climb the particular thing. So this is all about what are the new means. Okay, the innovative steps. The feature of that innovative steps that the involve technical advances what compared to existing knowledge or have economical significant or both. So if you are done with one, see already like a paracetamol, one medicine is there. Now I am going to what find one more new medicine. That medicine, whether it is a very cheap or whether it will be easily to curate the more number of people for the public, then it will be a patentable. Okay, so this involve technical advances. I going to done some technical advance with the already exist what components. Okay, but that molecular component, na, in that I'll done some advancement in that component to the existing knowledge or have an economical significant. This is very important, whether you have done some innovation or invention or new findings, whether it is economically significant or not, whether it will reach to the end, what the poorest of the poor of the nation of the country or not. That is very important. And both advancement also is there, economically also it's significant, then it is to be a patentable. Make this invention is not obvious to person skilled in that art. Okay, so there's an invention not obvious to person skilled. So I have skilled to what solve the fuzzy problem. I have a technique to solve this mathematical problem. This and all we cannot to say it is a inventive steps, but thing is that to make some advancement in the technique as well as the economical significance, then we call it as what? Innovative steps. Industrial application means what? I already told you that some small one IoT application is there, gas monitoring system. The same gas monitoring system we can capable to of being make use of any kind of industries. Okay, the innovation is capable of being made or use of any kinds of industry, that is all industrial applications. Okay, so the section 3 exclusions, what we can to be filed, what we cannot to be filed. Okay, the section 3A, we can what frivolous inventions or what invention contrary to well-established natural laws, like the natural law, Holmes law, Kirchhoff law. These natural laws are the machine that give more than 100% performance, perpetual machines. So this is an all come under the section. And see the commercial exploitation or primary use of invention, which is what the public order or morality. See anything to want to be exponential, what exploitation, any like a bomb or some other things, we cannot to be what patentable. Okay, public order or morality, gambling machine, like for example gambling machine, device for house breaking. So this kind of devices we are unable to file also. Okay, and the next section 3 exclusions. See the commercial exploitation or primary use of invention which cause a serious what a prejudice to the health or human, animal, plant life or other environments. For example, the biological welfare materials or devices, weapon of what mass destruction, what terminate gen technology, embodic steam cell, okay, embryonic steam cell. These are the we are not supposed to be what a judiciary related to judiciary. We are unable supposed to file a patent. Okay, the excluded patents are like GMs. What is that? Is all GMs means what modified what genetically modified microorganism which do not fall under the section 3 are patentable. So only you done with the already exist microbiology is there na, but you supposed to deposit that this microbiology biological molecules into the what Budapest Treaty. Okay, PCT Act and Budapest Treaties are the two common things to what review and what monitoring of the patent laws and the enforcements. Okay, so inclusion patents on GMOs, the exploitation which could not be contrary public order or morality or prejudicial to the human, animal, patent life or health or the environment. So these are the checks and balances. And see the mere discovery or scientific principles or the formulation of abstract theory or a discovery of any living things or a discovery of any non-living substance occur in the nature. So generally you get a one small stone. Okay, it is a very rare stone, like it's like what some other kinds of stone. It's not like some rock in your land. You are getting some new substance or discovering of any non-living things or living things, any substance you are found, some small insect nowhere found. This is now new invention you done. The formulation of abstract theory, the mere discovery of scientific principles, it's not come under the category of filing a patent. Okay, for example, Newton laws, superconduction phenomena such as what a proper property of creation of materials and different the mechanical shocks, discovery of microorganism, discovery of natural gas or minerals. You are getting one gas. Somehow you found you are telling some natural gas are discovered by me. These are not come under the category. You are not supposed to be a what having a patent on this. Okay. So next, I'll tell you the exclude patents on natural occurrence of microorganisms. Generally, the modification or what modified microorganisms, that is GMOs, or however are patentable. You are not supposed to be an already exist microorganism. You are not supposed to be capable of filing a patent. If you are done with the some modification and with the exist microbiological formation, it's a patentable. Okay, the mere discovery of a new forms of the known substance which does not result in the enhancement of known what efficacy of that substance. I already told you that like already fan is there, already light is there. I want to add fan light into fan. So this addition of two already existing things are not a patentable. Okay, this is all called mere discovery of a new forms. So adding of two things, making a new one form is a known substance which does not result in the enhancement of a known efficacy of the substance. Okay, so these are the some for examples, like the purpose of these causes, like a salt, ester, ether, polymorphism. Okay, polymorphous, metabolites, and pure from a practical size, isomer, mixture of isomers, complexes, combination of other diversities of a known substance shall be considered for the same substance unless they are differ significant in a property with regard to the efficacy. Okay, the crystalline from the known substances. So this is all we are not supposed to be a file a patent. Okay, and efficacy. Efficacy means efficiency of already the exist substance. The salt is there. What is the salt? How much is the what saltiness is there? What is the level of this ether? So everything with respect to the efficacy only we can say the what what to say the properties and the formation of the known substance are to be a patent. Okay, so these are we are unable to file a patent. The efforts of a salt, ester, ether, and what if you are using of the salt or ester, or I am using salt for some other purpose, it is supposed to be effort. It shows the what 50% of we get this kind of way, that and all we cannot to say it is a patentable. Okay, the section 3 exclusions, the mere discovery of any new property or new use of known substance or the mere use of known process, the machines or apparatus, unless such known process result in the new product or employs at least a one new reactant. So the use of aspirin for the health element, okay, the mere use of neem. See, instead of something, I am getting neem oil or a neem product for curation of any disease. It is not, we cannot to file a patent. The curation of any kind of disease or method, we cannot to be supposed to be a patent. Okay, if it is, if you are something extracting from neem tree, or you are using supposed to be some turmeric for a mixture of something or curating of one disease, is not to be supposed to be a patentable. Okay, right. See, the substance obtained by a mere admixture, the resultant only in the aggregation of the property of the component thereof or purpose of the procedure of substance for what complement of what procrastinated like antipractic or buffin. Okay, see, these are what medicine terminology, what medicine. Okay, the solution of surgery or color additive in the water for to soft drinks. So these all now come under what mixturing of two things is not supposed to be a patentable. The mixture resulting into the what synergic property of a mixture of ingredient, however, they may be patentable like a soap, detergent, lubricant, etc. So that are we can supposed to be a patentable, but what that is all the talk about synergic property of the particular thing. Okay, the substance obtained by the mere admixture, the resulting only in the aggregation of the properties of the component thereof, the purpose of producing such substance are not patentable. The synergic formation are patentable. Okay, synergic formulations are patentable, but general these things are not to be a patentable. You're supposed to understand. This all come under the category of what? 3E, next 3F. The mere arrangement or rearrangement. Rearrange, see, like first is a headlight. Headlight is in top front of the every vehicle. I supposed to be like slightly what tilt or twist with the some other direction. Okay, it's like it's one of the new invention. We cannot to climb like that. The climb is one of the very important thing. I'll tell you. I'll show you what are the important things. So the mere arrangement or rearrangement or a duplication of a known devices, each functioning of independently of one another is known way. The bucket filled with the torch. Okay, the umbrella with the fan. Okay, this umbrella with the fan. See, already umbrella is there. You want to keep within an umbrella one fan. It's not to be what a patentable. A clock and radio in a single cabin. So clock and radio are keeping in the one same place. It's not to be supposed to be a patentable. The floor mill provide with a sewaging. Okay, so this all we are not supposed to be a patentable. Okay, the method of agriculture or horticulture. See the cultivating of what algae. Okay, the producing a new form of known plant or preparation of improved soil. So this all we cannot to say or we cannot do what the method of what agriculture or horticulture we cannot come under filing a category. However the agriculture equipment are patentable. Like I am using some tractor, I am using some tilers, I am using some instrument to what floor to till the what land. So that kind of equipment we can claim it as for patentable. The section 3 exclusion of a 3A, any process of medicine, surgical, curative or prophylactic, diagnostic, therapeutic or other treatment of human beings or similar treatment of animal to render them free of disease or increasing their economical value or that are produced. See, if you are curing of any kinds of disease method or what type of medicine, what type they are not to be patentable. The removal of a cancer tumor, the removal of a dental plaque or caries, okay, and the surgical process, how you are supposed to make a surgery for like you are curing one what uh, heart disease. The curation of heart disease is not to be patentable. The process related to the therapy, how you are doing therapy, the method of vaccination, how you are inserting the injection. So these are the blood transfusion. Okay, the blood transformation. These all not come under the category of what we are on. We are not supposed to be file any kind of patent related to this. The treatment performance on tissues we are doing with something with the tissue or fluid parameter removed from the body, the surgical or therapeutic or diagnostic apparatus, or we can use. See, I am using some one AI robot for to do some diagnosis of one disease. So that is to be a patentable. But what the method you are curing the what the disease is not to be a patentable. Okay. So these instruments are patentable. Generally, what the device we are using for the method to curation of what the disease are using to fill or do some vaccination or to do something, it's all supposed to be a patentable. Okay, so the patterns and the animals are whole or any part of sorry. So the plants and animal in whole or any part of thereof other than microorganisms. Sorry, somewhere I stuck. My PPT is visible, na? Kindly anyone reply?
Not visible, sir.
Not visible. Okay, okay. 1 minute. I'll somewhere I stuck. 1 minute. Unable to do anything. So far you got clear, na? Very, very clearly you have listened or not? How? 1 minute. I'll. One second. I'll come back. Kindly bear with 1 minute. I'll
சார் எல்லாத்துக்குமே இருக்கு. சாகரணி
My voice is audible. Sorry for inconvenient cause. I'll share once again.
என்னப்பா என்னோட கையெழுத்துக்கே பாருப்பா. சும்மா இதோ ஒண்ணு எனக்கு வைக்கிற முடியாதுங்க ஒரு 6 மாசம் கழிச்சு.
So I'll continue here. So the exclusion patterns and like a, my voice is audible, right? I'll continue
Yes,
now.
sir.
Yes, okay.
Yes,
Okay. Okay.
You can proceed. You can proceed, Thillai.
Okay, sir. Thank you, sir. Thank you. So the excluded patterns. See, I already told that the curation of any diseases, we are unable supposed to be file a patent. Okay, like see, you are combined or mixing of two seeds or two trees. So these things, the plants or animal in whole or any part of thereof, including seeds, varieties, and species, are essential biological process or production or propagation of plants. Sir, or any animals you are with some modification done with the what microorganisms are making any new things, it's not supposed to be a patentable. Okay, the clones are new varieties of the plant, and the purpose of a production of a plant or animal, it consists of entity or natural phenomena such as, I'll do later, madam, I'll do it consists of entry of natural phenomena such as what a crossing or a selection. This is not supposed to be what patentable. Okay, right. So the section 3, I'll section 3K, like mathematical model. I have an idea to solve the fuzzy problem. Okay, I suppose like a cross fuzzy problem or cubic game. I want to suppose to method to solve a cubic game. I have a method to solve what a chess game. So these are mathematical method or business method or algorithm or compute, even computer program per second. The but million instructions, like one component like I tell you that IBM Watson, it will compute the like oncological records of like 1,000 or 1 million records of oncological records. It will compute and it will give the result of within max to max 1 minute. Okay, this much of computation power is there, but we cannot to be patentable that one. The computer program by itself as a record, not a what a career. Okay, the new calculation machine, like a calculating machine or combination of only thing is that what combination of hardware and software is a patentable. Not only software, we cannot, as a computer science student, you supposed to know these things. You are studying cyber security, so cyber security, you are designed one what Trojan horse. You are supposed to be created one malware or antiware or virus. You are design one virus, so that virus we are unable supposed to be a patentable until it interact with the hardware. So this kind of hardware, it will affect like motherboard, it will affect, it will supposed to be affect a daughter board or processor, or it will affect with the what USB. So that kind of any combination of hardware and software is a patentable. One exclusion of what software cannot be a patentable. Okay, so the literacy, what literacy, dramatic, musical, artwork, or any other of aesthetic creation of including cinematographic work and television products. These subject matters are fall under the category of what copyright protection. Okay, we cannot to be a patentable these things. Like I done one cinematography for one new film. I have conducting one type of what a television, what one television what event. So this and all we cannot to be a patentable, like a literacy, dramatic, musical. Okay, so this all come under the section of what? Okay, copyright only. I want to suppose to tell you what exactly this copyright. So you think is that what exactly this copyright? Can you tell anyone what is the idea you have the copyright? Anybody have idea copyright? What exactly copyright? See, I'll tell you. See, copyright grants the creation of original work exclusively rights to control how their work is used. Okay, however, the breakdown to the key aspect of what generally in copyright in India, the originality. Okay, atomic protections like originality means the copyright protect original expression of idea, other idea themselves. So I wrote one poem related to one natural thing. So this is nobody written that words are in the way how I written, nobody not written like that. So it is a original. Okay, and the automatic protection means automatic protection, the copyright arise automatically upon a creation of the work. Okay, no registration is required, but it is offer what advantage discuss. I'll tell you in later. Okay, okay, that type of copyrightable work, the literature work like a book, article, poem, etc. Dramatic work, plays, screenplay, all those things. Musical work like a song, a composition, we can say. Okay, artist work like a painting. Okay, sublifts and photographs, how the way you are taking a photographs, it's all come under category of what copyrights. Okay, cinematographic films and sound recording, these all come under category of what copyrightable work only. Okay, so what exactly the rights to the copyright holder, the control copy of the work, that is called our reproduction. Okay, and the adaptation means that to create a dramatic work, the translation, dramatizations, all those things. The public performance, the control public performance of the work, like a plays, music, all those things. And the publications, like a control making of work with the public, and broadcasting, the control transmission of the work, and moral rights, the claiming authorship, protecting against what destruction and what situation. See, generally you're supposed to think that the product or process, other all things we can call it as what we come under, fall under the category of what copyright only. Okay. See, okay, sir, I'll tell you what is the copyright duration. You told you that for a patent it's supposed to be a 20 years. What are the product or process you are designed or developed? For copyright, what is the duration? You have one question. Okay, the copyright is minimum of 60 years. Okay, the literary, dramatic, music, artist work, generally the author lifetime, up to that author lifetime. Whenever you say I wrote one poem, until my death, nobody not supposed to use that kind of way. Or otherwise, if I before I die means 60 years, then the maximum duration of the thing, that copyright duration is all about 60 years. Okay, cinematographic film 60 years for release. Okay, sound recording 60 years for creation. So this is all about the duration. Generally, one thing you have to keep in mind, for copyright it's supposed to be a 60 years. Okay, for these things only for 20 years. Okay, so the registration oppositional but recommendable. Okay, and the provide a better evidence of ownership in infringement case, the registered with a copyright office under the government of India, all those things. Okay, so the limited copyright, okay, are using a purpose of like our criticism, camaraderie, and research may be permitted. Okay, exception to the copyright protection does not appear to idea, fact, new items, or government work, all those things we cannot to get a copyright. The importance of the copyright is what safeguard of the creative effort of author, artist, or what musician. The promote innovation, creating by ensuring what creations are rewarded for their work, and provide a legal framework for creation and to control how their works are used. This is all another one more important thing. And copyright infringement, the using of copyright work without permission is infringement. Okay, and the copyright hold can take a legal action against the infringement. Okay, see, or see, nowadays they're releasing one thing, the same way we are copying and we are using for our own thing. So the lyrics, we are not copied the same kind of lyrics for our own thing. It's all come under the category. It's all called about what infringements. You know what is mean by infringement? You know what is mean by infringement? Anybody idea what exactly infringement? I'll tell you what exactly the infringement is. In the copyright infringement occur when someone use the copyright work without permission from the copyright holder. It's all about the technical world called infringement. In a way that violate their exclusive right Here the deeper dive into the infringement. It's all called about the without permission of for getting permission from others, what the patent or copyright having, we are using, that is all come under a category of what copyright infringement. Okay, right. So this is all the come under the category of what exactly the copyright. Okay. So next is this 3M, the mere scheme or rule or method of performing mental act or method of playing game. So this is also, see, I can solve the problem, crossword problem in this way easily to can solve the problem. That also not come under the category of what we cannot to play, we cannot to file a patent. Okay, the scheme of learning of language, I can say i I am, he is, she is, the way I am teaching to you. Okay, or the way I am, how we are pronouncing the word. So this the method of learning of a language or method of teaching or learning, these are not come under a category of what patentable. See, however, the novel approach, okay, the novel apparatus for playing a game or carrying out of a scheme in the patentable. So, okay, if you are producing in the way we can one item where it is easily to solve the problem, that kind of a component we can be a patentable, but the method or scheme of solving problem is not to be a patentable. Okay, the presentation of the information, any manner or method of what expressing information whereby spoken word, visual display, symbols, diagram, informative record on the what a career. So these are not supposed to be patentable. The topographic of what integrated circuits. Okay, this is like IC circuits also we cannot to be patentable. For that already exist one IT sector is, what IP sector is there for what IC board, they only supposed to be take care of that. Okay, the invention which are the traditional knowledge or an aggregation of or duplication of known properties of traditionally known component or components. So the traditional knowledge already in a public domain could healing the problem of haldi. Okay, you know what is meant by haldi. Okay, any value addition of using traditional knowledge lead to new process or product which is novel, which initiative step or industrial apparatus. So we can use of neem to cure of acidity. Then it is a extension of what it can be a patentable. So in neem tree, how we are taking that, how we are forming one thing to make a curing of one disease, it's a patentable. Okay, so the invention fall with the section of what non-patentable. See, I'll tell you that already so many things were discussed which are not come under category of, fall under category of what not patentable. In the section 4, the invention falling within the section 21 after the Atomic Energy Act 1962 are not patentable, like interventions of related to component like uranium, beryllium, thorium, plutonium, radium, graphite, lithium, and more are notified by central government from time to they will give some guidelines. Through that, if we are not come under a category, we are unable supposed to be a patentable. The stage for filing of a grant of patents, see obtaining of a patent, see filing an application for a, see I'll tell you here, with one of the applicant office based on a traditional judiciary office of reside on application or agent, they pay on the required fee. See, there is some fees are there, and we have lot of what forms are there. From form 1 to form 30 forms are there. I'll tell you what are the forms and what we supposed to do all those things. Okay, the file under the applications of the forms, I'll tell you their form like 1 to 9, like a form 1 for application of a filing. Okay, up to like 5 6. Okay, the agreement form, what undertaking form, complete specification, so many things are there. Form 9 for request for up to 8 are normal forms. Form 9 for publication, and form 9 into 2 18. The form 18 is for examination of what application for patent. Okay, 10 and these are 10 and 13 are the amendment of patent death. If anybody is the inventor is a death, then we have to file the forms like Form 10 and Form 13 for amendment of patents. Okay. Form 11 is used for what? Direction of what? Control, the power of controller, the power of ownership. For that, we supposed to file a form patent form 11, form 12 for request for grant of patent, the wrongful opposition. If anybody is given the pre-examination, then wrongful opposition, we submit the form 12. And form 13, I already told you that amendment of the patent death 10 and 13. Patent 14, form 14, opposition of amendment or a restoration of or surrender of a patent. I don't want, I'll surrender this technique. Nobody hereafter, if they use anybody, I am not not, I have not any no problem for us like that. If we have any commitment, then we can file that patents. That is all about what a surrender of patents. The form 15 restoration of patent, form 16 registration of a title. Okay, like a 17 already told you that 18 for examination, 17, 19, 20, 21 is our compulsory license. What a revocation of a patent and a revision of terms and conditions of license. Form 20, 21 is a request for termination of compulsory license. Form 22, the application for register patent agent. Okay, the restoration of name in the registration or patent agent. So many things are there. Okay, so the request of permission for making patent is the thing. And if you want to, it's the form 23, the restoration of name in the register of what patent agent. Okay, 24 for our civil court, 25 the form like a 25 to up to 39, 25 and 39, request for permission for making patent application outside India. If you want to the PCT Act, Budapest Treaty and what PCT Act, you're supposed to file these two forms. Like if you want to get the German patent or US patent or some other country patent, you're supposed to file a patents like form like 25 and 39. And the 26 the form of authorization of the patent agent. Okay, and 27 is a statement regarding to work of the patent invention for what commercial states. So this is all the patent form number 1 to 30 patents forms are there. And the duration of the patent, if you want to file a patent, what to say, you file within after the 18 months, file a patent with minimal cost application. You will get after 18 months only publication. If you file amount for yearly examination, it's supposed to be published as much as early within 1 month. So these are the general way, supposed to know this. And I'll show you one more thing. I'll show you some other things. I'll stop sharing. See, you can, the information concern about the applications, the details are available at this thing. So I'll share the entire screen. Then it is easy for. So look at here. One minute, I'll type here. See, first you go directly to Google. You can type one website that is all about, you can get it everything from here, IP India. Okay, so IP India, you can get the first link, official website for intellectual property right. So you can see here the patent, design, trademark, GI, geographical indications. Okay, what we are given, see everything here in this portal only. You can look at this taskbar. Okay, these are the tabs. You can find it here: patent, about us, administration, publication. If you've done any publication, if your patent is application is that, you can get it from here, journal. So I'll click here one journal. See, once you've done everything, you can get it here. Like, see, I'll show you one. Like recently they published on 25th, 24th. Every Friday they will release the what are the once get to the examination, every Friday they release the what are the newly inventions are done within the things. Okay. So you can see here one invention. Like I'll going down. See this. Like you look at this one first application number. I'll see here. This is application number 2023-10, and the date of 10th 8th month of 2023 they filed. 24th 24/5/2024 it got published. Okay, what is the system and the method for submental intubation. So some medical some things are there. They given the abstract and the number of claims, 10 claim. The number of page of the specification is a 23. Everything you will get it. Similar like this is all after publications. See, after you get a grant, you will get the grant certificate separately. But this is the first thing. Once you done a filing, see if I want, I'll note down this application number. I'll go to the same IP website. Here the comprehensive e-filing is there, na? Public search. If you click here, this public search, I am public search patent. I'm going to this patent tab. You go to the application status. I'll fill the same application number what I copied from there. SKDWWC. So once you done that, enter the code. It's I think invalid capture. I'll enter re-enter H7E capital H3Q. Okay, so show the status. You can get about the specific of who is the applicant name, title of the invention, field of the invention. Okay, and the email ID. You can get the here the view documents. If you go down, you get it everything from here only. Okay, applicant type is ordinary application or any. I'll show you that login also later. Okay, the details of filing 2010-2023. Surya Prakash, the train safety shield, third eye, like that, the biomedical engineering. They given that view document, you can get it the specification form 3, form 1, form 2, form 3, form 5, okay, form 9, and form 18 for examination also. If you click a examination, you can get it the examination applications also. They're done with this is all like a forms. You can get all the forms. What is the form? The 15th March they will go for examination also. So each form you are filing, there is some what the government fee is there. You're supposed to pay that and get the consent. Okay, and okay, this is how you generally get. So here in this only you can go back in this. See here pattern search. See this INPASS is there, na? INPASS Indian Pattern Advanced Search System. INPASS. INPASS you get the like pattern title IoT based IoT if I'm giving something IoT plus machine learning plus healthcare. Okay, if I type like that, I will type caption down 7SQ capital OV and 0. So search here, what are the patterns already related to that it will show. It's not supposed to be same like AML and IoT based smart healthcare system, AML IoT based healthcare monitoring system, so system and apparatus based on AML. So many things that the design wearable sensor to provide health notification using machine learning IoT based technology. Okay, you can see here design a wearable sensor to protect healthcare notification using machine learning and IoT. So if you are done something, whether it is or correlate with the same thing, other yours is new invention, you supposed to be get idea. It's not supposed to be a patent. The same thing we cannot supposed to be a patentable. So you come up with the different invention that is not supposed to be a mere arrangement or rearrangement or anything. So it's supposed to be very clear and crisp. and this is a website you can get it, IP India. So if you want to do trademark, you can click into trademark, design patent, and what else, that's all, geographical indication, trademark. And this is how generally, if I want to get into login, I'll show you the login also. Comprehensive filing and going with the login credentials, IP India e-filing pattern. So you can click here comprehensive e-filing, down to that for filing and all here, for public search here, status, e-registration, trademark, everything you will get it from here. Okay, so I'll click here within okay, I'll go down. So through this I'll typing my credentials. I have login with that India. So I'm entering with this credentials 6F6U2. So this is individual login. It's not a agent login. So these are the forms. Like you can see here, this is a website. The Government of India, Ministry of Commerce and Industry, the Department of Industrial Policy and Promotions, the Control General of Patent Design and Trademark. Add application already filed under the SIP scheme. There are also some schemes also is there. So you can get it this form to, you can click here, you can get all the forms, form 1 to up to Form 28, that is a Form 28 all about miscellaneous. Form 30 is all about miscellaneous. This all, each form is one thing it shows. I already told you that what each form is all about. Okay, so so you can see here the file and the compulsory what complete specification after provisional specification, Form 2, Form 9 for yearly examination, Form 13 for what amendment to the patents, amendments any death is happened, the amendment of patent we supposed to file. Form 18 for what the request for examination after 18 month of publication. Form 20 for it's a small entity. If you are done with any MSME or any incubation center, you supposed to file your company. You have to file under the category of what small entity. The declaration of small entity, the form 28 you supposed to use. Okay, and form 13 for miscellaneous and the renewal of pattern, all those things. I'll show you one new application. If I click here new application, the proceed to e-filing. So you can type, you click here, see here only the conventional application, what a conventional application, diversion of ordinary application, or it is what a PCT national phase application, or conventional application. So many pattern of addition for conventional application, ordinary application. So many things are there. What type of application you supposed to click? I'm clicking here ordinary application. The type of specification, whether it is a provisional or complete specification, you have only one idea. Then you can go, or you can come up with what the filing of what provisional. If you have the whole thing, then you can go with the complete specification. I'm here clicking complete specification. Number of pages are 10 pages of my document. Number of claims, I'm going to claim with the 5 claim in my invention. Number of pages here I'm giving 2. Abstract, it's all about that one page write up or one page abstract about one page write up about my invention. Okay, number of drawings I'm giving here, number of pages of drawing 2, number of drawings 4. So you can go down, title of the invention, address of the service, state, mail ID. See whatever the things here written in the red color, no? Okay, the number of pages including drawing abstract, the claim property are going to be for fees calculation. See how many, see the fees calculation not supposed to be a same, it will be dynamic with respect to number of claim and other things, it will. Okay, so it's not to be a, like a same, earlier it was to be the same one. Now the fees also they are collecting with respect to number of claims you are going to get. Okay, so other things you can see here in the abstract description claim. So you can add here like add abstract so like that you have to ask you have to add all the applicant with the name, nation, address, pin, phone number, mail ID, country, state, all those things you supposed to be fill. You can add like that similar way, you can add like a gender, name, nationality, address, country, all those things you can add applicant, add inventor. Now after that you have to come up with the declaration by the applicant, the provide specific related of information, the field with respect to of these things. Okay, and you have to the patent corporate treaty, that is all about PCT Act para 6. Okay, you have to or para 5. So these all you have done any disclosure of specific biological material from India. If it is the case, then you have to deposit your biological materials to the where PCT Act, that is a patent corporate treaty. Okay, and you have to come across with the para 6, para 5, para 8. So all done, all things are done. Then you can go here form 9, form 18, or you can click agree. You have to save. Once you've done the save, I'll show you one drafted file. So this is how it's really drafted file. You can click here. I'll show you the preview. See here, you can get it like name, national address, country, all those things. So here you can get it like a title, address, and priority particulars, all those things. Once you're done, if you once you're done, you have to here the preview, edit, upload, discard, and sign documentation. You're supposed to sign with the digital signature, then only it will be a valid one. Okay, if you click here upload, then you have to supposed to upload all these document: form 1, provisional specification, drawing, request for early publication, request for examination, request for small entity, whichever is applicable to you. You supposed to the evidence of registration under SSIF form 28, that is for small entity, the proof of right, the sequence list in PDF, list in text. Okay, and the complete specification and priority document, traditional for priority document, statement of undertaking, power of authority, and a declaration of inventorship, and a figure or abstract. So this many things you have to upload it, and finally you do the you done with the what digital signature. Finally you done with the payment. Then finally you will get the application number. With that application number, I already told you that this public search is there, na? The patent in that you can search with that application number, you can do all these things. Okay, I hope everyone supposed to understand what exactly, somehow you understand what is IPR and what is the forms are there, what is the act we supposed to know, that what are the things we supposed to be patentable, what not supposed to be patent, what is mean by copyright. Okay, and what to say, a trademark, geographical indication, so many things we discussed so far. And I think I'll stop here. If you have any queries, kindly ask me. Do you have any queries? Kindly ask me. I'll stop sharing. Kindly raise, or you can post your question in what's chat. What feasible way you want to interact with me, you can interact with me, no issue. Prabhu, Aravind, Shakti, Naveen Kumar, Madan, Jana, or otherwise you can post your questions. If you are unable to unmute, Bharat, Rajashekar, Rahul, Rohit, Swati, nothing, sir. Okay, good. Somebody wrote Prabhu. Nothing, sir. Okay, if you want anything, interact with me, kindly interact with me, no problem. If it is very simple question also, with respect to this one, how who control IPR in India? Central government only. Central government only. There is IPR India, controlled by the central government only. Any other question? I think who's that? Cyber. What's the name? Ibrahim. I think I answered your question. Who control IPR is in India, sir. In central government has come under the central government IPR, intellectual property right. I told you, there are 4 offices, one in Kolkata, Mumbai, Chennai is there, and Delhi. These are the 4 places, the IP headquarters, and they are taking care responsibility of each one thing. And from Tamil Nadu, they are taking care of what geographical indication for a design Kolkata. Okay, okay, good, good. Right. I think my side is all got over. Muthu sir. Muthuswamy sir. Any other doubt? Coordinator?
Dear guys, any other doubts? Actually, our Dr. Thillai Arasu, he has explained everything A to Z, where we have to start the document and how you are going to make a patent and everything he has explained, even though that is a forms, all the forms he has explained everything. As a student, as a faculty member, you can able to drop the documents and maybe you can file it. So that level he has explained. So if really it is a useful session, I hope maybe everyone you have understood. If you have any clarification, you can ask our Thillai Arasu. He is ready to clarify your doubts.
I think few of them already asked the questions, sir.
You have studied, even though first year MC already you have studied IPR subject in the first semester itself, and our cyber security students you are going to study, and then even though as per our Paavai engineering college and NBA and NAC, so every student, every faculty member, we are filing the patent in our Indian office. I think most of the student already we have filed. You have n number of doubts. It is an open forum. You can ask the doubts. Definitely, our Thillai Arasu will clarify your doubts.
Sir, already.
First year MCA, you have studied IPR subject in the first semester itself. One semester you studied that subject. Yeah, Thillai already first year MCA, they have studied the first semester itself IPR subjects.
Okay, sir. Good, sir. Good. Sir, few of them already asked the question, sir.
And IPR, they have studied first year MCA.
Okay, sir. Nice, nice. Sir, few of them already they given come up with the chat. Already answered. I think now we can conclude, sir.
Okay, no problem. So I'm going to give your mail ID and the phone number to our student and the faculty member. If they have any doubt, maybe they will drop the message.
Sure, sir. I'll help them. No issue.
Any other doubt, guys? You feel free to, you can ask. I hope everyone you have listened that webinar in the proper way, means definitely you have doubts. Maybe I think afternoon session, I think some of the student maybe you slipped, means you don't have any doubts. Very simple logic. If you listen that webinar properly, means definitely each and every student you have some doubts. Our great Vignesh Reddy and other panel member, team member, they are standing in front of me. You can ask the questions. if you attend the webinar in the proper way means okay. Thank you. Thanks, Tillai Arasu sir. Even though your busy schedule, I have invited immediately. You have accepted my invitation, and today you have given excellent, outstanding lecture
Thank you, sir.
presentation
Thanks a
to our
lot.
students and faculty member regarding IPR. Thanks a
Thank you,
lot.
sir.
So
Thank
we are
you.
expecting your presence in person in Paavai very soon. So I'm going to make a plan, and you have to come
Sure,
over
sir.
here and you have to deliver the lecture in another latest new innovation title. So we will
Sure, sir.
discuss
Sure,
later.
sir.
So anyway,
Sure, sir.
thanks a lot. Anyway, thanks a lot for your great presence and excellent, outstanding presentation.
Thank you, sir.
Dr.
Thanks a
Tillai
lot.
Arasu sir,
Thank you, sir.
professor
Thanks a
and
lot.
IPR coordinator and the School of Computing Science and Engineering, Reva University, Bangalore. Thank you, Tillai.
Thank you, sir. I am going to leave,
And
sir.
our
Thank
great
you.
faculty member who has organized this webinar. Thank you, Tillai. And our great
Thanks,
faculty
sir.
member, you have done the wonderful job. So you have organized excellent webinar. Thanks to all. And our great pillars of cybersecurity and MCA. So everyone, you have supported a lot and you have listened, I think, entire session. I hope everyone you have received excellent input from this webinar related patent and there is intellectual property rights. Thanks to all.
Thank you, sir. Thank you.
Thanks to all.
Thank you.
Okay.
Thank you, sir.